Hello and welcome to this episode of Tax Snacks, which is looking at the Court of Appeal decision in Medpro, which was released on the 19th of January 2026. Now, you may remember that last year Medpro caused a bit of a storm because in it, one of the judges, Marcus Smith, made a decision to ignore, or made a decision that the guidance given previously in relation to late appeals by the upper tribunal, he said that was wrong. And so in brief, what that guidance was and is that when balancing all of the factors in determining whether or not you're going to allow a late appeal, the court has to give particular weight to this idea that deadlines must be respected. And Judge Marcus Smith said that, in fact, no special weight should be given to that. Now, it was an interesting case because it's one of those rare occasions where the two judges in the case actually disagreed, and because Judge Marcus Smith was the chair, he was the judge who had the casting vote, and so the taxpayer actually won, and HMRC had to appeal to the Court of Appeal. So that appeal was heard late last year, and the judgment was handed down just recently. And so the way that the issues were put to the Court of Appeal was it was about the exercise of a discretionary power to extend time for appeal. And as you all know, this was a VAT case. So it was Section 83G6 of the Value Added Tax Act 1994 that was in point. So that there were 30 days to make the appeal, and then an appeal after that 30-day period could only be made with permission, effectively, and that would be the permission of the tribunal. Now, in the first tier tribunal, the appellant company Medpro was refused permission. They were appealed to the upper tribunal. So Lord Justice Lewison gave the judgment of the court, with which the other judges agreed. It was Lady Justice Whipple and Lord Justice Mills, and he started by drawing the analogy between Section 83G6 and the Rule 20 sub 4 of the tribunal procedure rules, which I think is an important link to have made, because obviously this is an issue that affects both direct and indirect tax appeals, and Lord Justice Lewison starts by telling us that actually we need to look at starts by telling us that the jurisdiction is effectively substantively the same. Now, he also, at least implicitly, approved what was said by the upper tribunal at paragraph 83 of their judgment in relation to procedural landscape, quoting, "Appeals represent a late stage in disputes between a taxpayer and HMRC. Before one gets to an appeal, there will typically have been an inquiry by HMRC, decisions including assessments and possibly statutory and non-statutory reviews of those decisions. The process can take a long time. Quite how this should inform extensions of time is a matter that can be debated, but there can be no doubt that the process within which appeals sit is relevant in construing the nature of the power of time to extend." He then went on to talk about the fact that Martland in the upper tribunal and Khatib set out the way in which to approach whether or not to allow a late appeal, which is with the three-stage test, which we'll come to in a minute. And what was raised by HMRC here was not whether the guidance was flawed, but whether it is actually permitted for the upper tribunal to formulate guidelines for the exercise of discretion by the first tier at all, and in particular in relation to giving significance to the factors to which significance was given in this case. So, The respondent argued that even if the upper tribunal was entitled to give guidance, the guidance in Martland is incorrect. It's flawed, I think is the expression used. So I'm not going to go into the facts, because the facts were essentially that there was a right of appeal within 30 days. The company taxpayer didn't exercise it, and so it could no longer appeal without permission, which is then a statutory discretion given to the court by the Value Added Tax Act, section 84G6. So to turn now to what the Martland guidance actually is, because there are two parts of it, and if you recall the upper tribunal decision, the upper tribunal accepted that the three-stage test as set out in Martland should be applied. What Judge Marcus Smith didn't like was this weight to be given to the two factors. So the three-stage test is this: you have to establish the length of delay, and if it is very short, then that amounts to a breach which is neither serious nor significant, and then the first tier is unlikely to need to spend much time on the second or third parts of the test. But you do need to always consider all three steps. The second was you need to look at the reason or reasons for why the default occurred. And thirdly, you have to look at all of the circumstances of the case, which is a balancing exercise to assess the merits of the reasons given for the delay and the prejudice which would be caused to both parties by the grant or refusal of permission. And it should be made very clear that that three-stage process hasn't been challenged at any stage in Medpro. So that stands. But what was objected to was the further gloss that the upper tribunal in Martland put on that test, and said the balancing exercise at stage 3 should take into account the particular importance of the need for litigation to be conducted efficiently and at proportionate cost, and for statutory time limits to be respected. Now, that echoes the position that applies under the CPR, and that was one of the points that was argued in the upper tribunal in Medpro, was, look, actually the CPR has a different origin to this, and you cannot carry across the same the same balancing weight for statutory time limits into the tribunal rules. But that last point was reiterated in Khatib, where the upper tribunal said, "We have, however, concluded that the FTT did make an error of law in failing to acknowledge or give proper force to the position that, as a matter of principle, the need for statutory time limits to be respected was a matter of particular importance to the exercise of its discretion." Again, this was reiterated by the upper tribunal in Roma Civ, where it was said that the exercise of a discretion to allow a late appeal is a matter of material import, since it gives the tribunal a jurisdiction it would not otherwise have. Time limits imposed by law should generally be respected. Fair enough. And so it is this approach that was challenged by Medpro in the upper tribunal, and on which it narrowly won by convincing Judge Marcus Smith, and which HMRC then took back to the Court of Appeal here. And as I mentioned at the outset, there are two parts to this. The first is whether or not the upper tribunal was in fact entitled to give that guidance to the first tier tribunal. And here, Lord Justice Lewison gave a resounding yes as his answer. He quoted the Supreme Court, Lord Carnworth, in Crown on the application of Jones versus the first tier tribunal, and talked about, this case talked about the reorganisation of the tribunal system back in 2007 when we got the TCEA, and the parts of that judgment that Lord Justice Lewison quoted are the following. Whereas here the interpretation and application of a specialised statutory scheme has been entrusted by Parliament to the new tribunal system, An important function of the upper tribunal is to develop structured guidance on the use of expressions which are central to the scheme, and so as to reduce the risk of inconsistent results by different panels at the first tier level. So that was held to be important by the Supreme Court. Then a different Supreme Court case, BPP Holdings in 2017, Lord Neuberger repeated the point that it was an important function of the upper tribunal to develop guidance, and observed that observation was made in the context of an imposition of sanctions for a procedural default. You may recall that BPP turned on an unless order against HMRC, unusually, which ultimately resulted in the litigation, HMRC being blocked from participating in the litigation. So, what Lord Neuberger said: it is not for this court to interfere with the guidance given by the upper tribunal and Court of Appeal as to the proper approach to be adopted by the FTT in relation to the lifting or imposing of sanctions for failure to comply with time limits. And it should be noted that in case law it has been acknowledged that there is a distinct similarity between a provision of a time limit and the situation here where somebody is looking to appeal out of time, because what they have effectively done is ignored a time limit. So, we have twice recently affirmed a similar proposition in relation to the Court of Appeal's role in relation to the proper approach to be taken in such cases by first instance judges. The guidance given by Judge Sinfield in McCarthy and Stone was appropriate. As Mr. Krasinski QC, who appeared for BPP, pointed out, it is an important function of the upper tribunal to develop guidance so as to achieve consistency in the FTT. And by confirming that guidance, in this case, the senior president, with the support of Lord Justices Moore, Bick and Richards, has very substantially reinforced its authority. In a nutshell, the cases on time limits and sanctions in the CPR do not apply directly, but the tribunals should generally follow a similar approach. And here, Lord Justice Lewison made 4 points. The first one was that the Supreme Court clearly recognises that the upper tribunal is entitled to give guidance to the FTT as to the proper approach to the lifting or imposing of sanctions for failure to comply with a time limit. And he then says on the face of it that would include a failure to comply with a time limit for an appeal, and I think that must be correct. The second point is it is an important function of the upper tribunal to give guidance so as to achieve consistency. The third, although the cases on time limits in the CPR do not apply directly, tribunals should generally follow a similar approach, and the phrase time limits is not limited to any particular form of time limit. And finally, the guidance that was approved was guidance attaching significant weight to certain factors. So there, I think what Lord Justice Lewison is doing is he's pointing out the similarities between the position here and the position in BPP. So that then takes us to the Court of Appeal decision in BPP, which Lord Justice Lewison also felt was worth considering. He looked primarily at what was said by Lord Justice Ryder in that case. And he said the key question underlying the two decisions can be characterised in the following way: whether the stricter approach to compliance with rules and directions made under the CPR as set out in Mitchell and News Group newspapers and Denton and T.H. White applies to cases in the tax tribunal. So those were cases on sanctions in a CPR jurisdiction. The two conflicting decisions of the upper tribunal on the point came to different conclusions. For the reasons I shall explain, I am of the firm view that the stricter approach is the right approach. In the circumstances that the tax tribunal rules are silent on the question, did Judge Mosedale in the FTT make an error in law in according the efficient conduct of litigation at a proportionate cost and compliance with rules, practice, directions and orders significant weight as part of her consideration of the overriding objective? And Lord Justice Ryder came to the conclusion that no. She wasn't wrong to do that. So what Lord Justice Lewison in Medpro then went on to quote was two further passages of Lord Justice Ryder's decision in BPP, in which he said that a superior court of record, like the upper tribunal, is entitled to develop its own guidance and precedent, and that there was significant merit in identifying and implementing new practices and procedures. So that was one point that was made. The second point that was made was that the policy being developed, there was no justification for a more relaxed approach to compliance with rules and directions in the tribunals. And while the policy might be set out more clearly by the Civil Procedure Rule Committee, the terms of the overriding objective in the tribunal rules incorporated proportionality, cost and timeliness, and it should not need to be said that a tribunal's orders, rules and practice directions should be complied with in like manner to a court's. He went on to say, if it needs to be said, I have now said it. So one would have thought that that might have put to bed that argument, and perhaps it did in relation to sanctions, clearly not in relation to this. It's a slightly different form of sanction, isn't it? But a sanction nonetheless in some ways, preventing, by putting a time limit on when you can appeal. So he went on, this is Lord Justice Ryder, went on to say, a more relaxed approach to compliance in tribunals would run the risk that non-compliance with all orders, including final orders, would have to be tolerated on some rational basis. The interests of justice are not just in terms of the effect on the parties in a particular case, but also the impact of the non-compliance on the wider system, including the time expended by the tribunal in getting HMRC to comply with the procedural obligation. Flexibility of process does not mean a shoddy attitude to delay or compliance by any party. So what Judge Lewison thought about that was that decision, and this is what he said, this decision plainly held that there would be a change of culture in the tax tribunals and that the approach in Denton should be followed, even though the tribunal rules were silent on the weight to be attributed to the various factors to be considered. Now, I'm not sure that that can be what Lord Justice Ryder was in fact driving at, because he cannot have said that there would be a change of culture in the tax tribunals if there was a less strict approach, simply because he couldn't know that. So I think that paragraph 27 is perhaps poorly worded, and perhaps what was held was that the risk of a change of culture in the tax tribunals, should there be a different approach to delay, was reason enough to say, no, we need to adopt the same approach as in civil procedure rules jurisdictions. He did note that the Supreme Court didn't expressly endorse this passage, but said nonetheless that Lord Neuberger said that the Supreme Court should not be taken as approving all of the Court of Appeal's reasoning, but Lord Justice Lewison felt that this reasoning was consistent with the decision of the Supreme Court, and so he had to follow that decision. Again, I'm not sure, in light of what Lord Neuberger said in the Supreme Court in BPP, that necessarily follows, but I'm not a Court of Appeal judge. So he then sets out a little bit more from BPP, and then goes on to ask whether or not the fact that the power is discretion conferred by statute, whether or not that makes a difference to the position. And he quotes from the upper tribunal decision in this case, saying that what they said was, the question is whether the approach, however apt, is permitted as a matter of the statutory construction of section 83G6. If, and that is the reading of the case law following Martland has elevated the two special CPR factors to a more prominent position at the top table, then the approach needs to be justified by, or at least not be inconsistent with, the words of the statute. And up to that point, the upper tribunal judges had agreed, and that's where this disagreement comes in. And essentially, Judge Marcus Smith has held that the upper tribunal didn't have power to give guidance to the FTT, and that was because this was a statutory discretion allocated to the first tier tribunal, and that binding guidance on the weight to be attached to particular factors in the absence of any change to the legislation would amount to a fetter on the exercise of the discretion. So that was why Justice Marcus Smith said, no, I don't agree with this. What Lord Justice Lewison had to say about that was that there was some tension between that view on the one hand and the upper tribunal's guidance in Martland, which, if this is to the three-stage test, which Judge Marcus Smith said, yes, the three-stage test is unimpeachable, but I reject this idea that you can elevate factors within it. Lord Justice Lewison also pointed out that guidance like this had already been approved in BPP by the Court of Appeal and the Supreme Court, even though the tribunal rules in question were silent on the matter of weight to be given. And finally, he said he couldn't identify which part of Section 83G sub 6 Judge Marcus Smith felt to be inconsistent with Martland. So that was how he dealt with this point about it being a statutory discretion. Now, I'm not aware that a number of cases were quoted, but there have been a number of cases in other contexts about fettering of statutory discretions, and indeed it's still a live issue, or at least it was a few years back, within the judicial review jurisdiction. I'm going to talk about that a little bit more just before I finish. But what Lord Justice Lewison went on to do was to quote the case of the Court of Appeal in the case of Perrin Panathan and City of Westminster Magistrates Court, where there is a power of the magistrates to award costs that within the statute was ostensibly unfettered. It was described as an ostensibly unfettered discretion by Master of the Rolls, Lord Newburger. But what he went on to say was the fact that Section 64 contains no fetter on the magistrate's discretion as to whether, and if so to what extent, to award costs in favour of a successful party does not mean that a court of record cannot lay down guidance or indeed rules which should apply, at least in the absence of special circumstances. It is clearly desirable that there are general guidelines, but it is equally important that any such guidelines are not too rigid. There is a difficult, if not unfamiliar, balance to be struck, namely between flexibility, so a court can make the order which is most appropriate to the facts of the particular case, and the circumstances and behaviour of the particular parties, and certainty, so that parties can know where they are likely to stand in advance, and inconsistency between different courts is kept to a minimum. A similar point was made by Lady Rose in the Competition and Markets Authority and Flynn Farmer case, where she said, even where a statutory power conferred on a court or tribunal to award costs appears to be unfettered, it is appropriate for an appellate court to lay down guidance or even rules which should apply in the absence of special circumstances. And Lord Justice Lewison went on to say that even though those are both cases about costs, there was no difference in principle between that discretion and a discretion to extend the time to appeal. He also points out that neither of these cases were put before the upper tribunal in Medpro. So the next important point that was considered was the issue of weighting, and this dealt with the particular concern of Justice Marcus Smith that the Martland guidance gave specific and significant weight to two factors not expressly mentioned in Section 83G6. He then went on to place reliance on changes to CPR Rule 3.9, which had enabled the court to take the approach that it did in Denton. So in essence, he relied on the fact that the rule had changed to make more specific mention of these things. And Lord Justice Lewison criticised that because he said the BPP case, the Court of Appeal had made it clear that in the tax tribunals, a change in approach to non-compliance did not need to wait for a change in the rules before adopting the Denton approach. So he said that's already been sort of debunked in effect. And that it was made equally clear that there was nothing in the wording of the relevant rules that justified a different approach between the civil courts and the tax tribunals. And so Lord Justice Lewison came to the conclusion that there was no inconsistency with the statutory power in Section 83G6 that would preclude the approach of giving extra weight or giving guidance that extra weight should be given to the compliance with statutory time limits factor. He went on to say, in a way very reminiscent of school teachers, a time limit is not simply a target date, it is there to be respected. That in itself justifies the attribution of significant weight to it. So there we go. He also criticised the characterisation of the Martland guidance as amounting to a fetter on discretion, describing it as overblown. And he said the three-stage test described in Martland requires the FTT to consider all the circumstances of the case, and that expressly recognises that there is a judicial discretion to be exercised. And he then says, well, therefore, in his view, Judge Marcus Smith was wrong, and he preferred the reasoning of Judge Cannan. And he went on to say, in either case, a superior court or tribunal is entitled to give guidance about its exercise, but he stressed 3 points. First, guidance is merely that, guidance. Where a superior court or tribunal gives guidance, the inferior court or tribunal can depart from it if it has sound reasoning for doing so. And he references back to Lady Rose's speech in a Flynn Farmer, where she said that, and he says specifically the bit that supports that is where she says, in the absence of special circumstances. So that was his first point there. He then, he had 3 points, didn't he? My apologies, I've lost my place. Here we go. Yes. So that was the first point. His second point, he said it is appropriate for an appellate court to lay down guidance even where discretion appears to be unfettered. And thirdly, that the Supreme Court in BPP had approved the giving of guidance when non-compliance with time limits was an issue. So that dealt with the first point of whether or not the guidance could be given. Lord Justice Lewison then came on to the appropriateness of the guidance, which he considered more briefly. Having set out the two parties' arguments in brief, he then went on to quote Data Select, Justice Morgan, where he said at paragraph 34, applications for extensions of time limits of various kinds are commonplace and the approach to be adopted is well established. He then went on to set out the test. So what is the purpose of the time limit? How long was the delay? Is there a good explanation for the delay? What will be the consequence for the parties of an extension of time, and what will be the consequences for the parties of a refusal to extend time? And then where he said, in my judgment, the approach of considering the overriding objective and all the circumstances of the case, including the matters listed in CPR Rule 3.9, is the correct approach to adopt in relation to Section 83G6 Value Added Tax Act. And importantly, in Lord Justice Lewison's eyes, what he then went on to say was that some of the cases stressed the importance of finality in litigation, and that point applies to an appeal against a determination by HMRC as it does to appeals against a judicial decision. And so Justice Morgan in Data Select saw no difference between Section 83G6 and the CPR. So, in turn, that all goes to the appropriateness of the guidance given by the court. And Justice Morgan had held that an application under Section 83G6 should be treated in the same way as an application for relief against sanctions. Lord Justice Lewison rejected an analogy drawn with cases under Section 33 of the Limitation Act 1980, or in relation to claims under the Inheritance Provision for Families and Dependents Act 1975, on the basis that these were a very different sort of process because of their circumstances. So he characterised the power to allow a late claim to be one where the matter had already been thoroughly investigated and it was an appeal against a decision, and those particular applications were in fact going to involve private litigation which raised claims that hadn't yet been investigated. He referred to an appeal under Section 83G as a true appeal against a decision already made. I'm not sure that is sufficient enough distinction to dismiss any reliance on those cases, but certainly Lord Justice Lewison did, and he heard the arguments. He went on to say, in my judgment, if the upper tribunal is entitled to give guidance on the exercise of a statutory discretion, then the UT in the case was correct in deciding that the Martland guidance, as amplified in Khatib, was entirely appropriate. And he then went on to say that even if there were any doubt about the guidance, it wouldn't be for the Court of Appeal to interfere unless the guidance was wrong in law. And he allowed the appeal, with Lady Justice Whipple and Lord Justice Miles agreeing. So obviously this is a disappointing position for the taxpayer. We'd finally got somebody had got a win on this, and a broader consideration was given to it. So it is disappointing. I don't know whether or not this is going to go up again. It may go to the Supreme Court, or at least an application for it to go to the Supreme Court may well go in. However, that is where we are at the minute. So if you've been following the case law, there have been a stream of recent decisions on permission to appeal out of time, relying on Medpro, both in the indirect and direct tax sphere. And unfortunately, while a lot of those were pushed back in any event, the Medpro argument is for the time being gone. However, I think it is really helpful that the Court of Appeal have pointed out that where the upper tribunal gives guidance, it is merely guidance, and if the the first tier tribunal can come up with a reasoned basis for not following that guidance, then that's perfectly acceptable. The other thing that I think is quite interesting in this case is what isn't said, certainly in the judgment, which is, in my view, it's possible that insufficient consideration might have been given to the cases on fetter of statutory discretion. Now, this is a line of cases which started with a case called British Oxygen, which has been quoted with approval in the tax courts, albeit in the special commissioners prior to the new tribunal system. So what was said in British Oxygen, and quoted with approval, I mean, it doesn't need to be its House of Lords decision, but which was mentioned in the special commissioners, was what Lord Reid said at page 625 of British Oxygen and Board of Trade, a 1971 case. And what Lord Reid said was this: the circumstances in which discretions are exercised vary enormously. The general rule is that anyone who has to exercise a statutory discretion must not shut his ears to an application. But a ministry or large authority may have had to deal already with a multitude of similar applications, and then they will almost certainly have evolved a policy so precise that it could well be called a rule. There can be no objection to that, provided the authority is always willing to listen to anyone with something new to say. Now, yes, this is about administrative law, but it applies equally, in my view, to tribunals, particularly where non-appealable applications of guidance might have been made. So, in my view, what Lord Justice Lewison says takes us pretty close to that point anyway, but it wasn't brought to the attention of the court. The second case that I want to mention, so that is British Oxygen quoted in Gorge Fabrications before the Special Commissioners. is a case actually quoted in British Oxygen itself called Kinnock, Crown and Port of London, ex parte Kinnock Limited, which is a case from 1919, and British Oxygen quoted that case with approval, and what it quoted was what Lord Justice Banks said at page 184. And he said this: there are on the one hand cases where a tribunal in the honest exercise of its discretion has adopted a policy and, without refusing to hear an applicant, intimates to him what its policy is, and that after hearing him it will, in accordance with its policy, decide against him, unless there is something exceptional in his case. I think counsel for the applicant would admit that, if the policy had been adopted for reasons which the tribunal may legitimately entertain, no objection could be taken to such a course. On the other hand, there are cases where a tribunal has passed a rule or come to a determination not to hear any application of a particular character by whomsoever made. There is a wide distinction to be drawn between those two classes. And what was said in the House of Lords in relation to that is this: I see nothing wrong with that, but the circumstances in which discretions are exercised vary enormously, which is the passage that I've already mentioned that was quoted with approval in Gorge Fabrications. And so, in my view, notwithstanding that we have come to what is probably a fairly sensible position, there is still plenty of room for development and argument here, even outside of Medpro if it doesn't go to the Supreme Court. So I think this is still an area to watch closely. Thank you for listening, and do watch any of our other videos from Tax Snacks that might take your fancy.